Good evening, I'm Lauren Culver.
And I'm Nicholas Kwolek. Thank you for watching KX News. Leading the news tonight, who owns the mineral rights underneath Lake Sakakawea?
There's no clear answer, at least not right now, but billions of dollars are at stake over the matter.
Our Renee Cooper has spent months digging into this complicated question. She joins us now to share what she's found. Hi, Renee.
Hi, Nicholas and Lauren. A number of landowners in our state have sued North Dakota over the mineral rights they claim as their own. But before we get into that, let's go all the way back to statehood. Back in 1889, the United States government granted the state of North Dakota's Department of Trust Lands 3.2 million acres of land. That's the two sections in green in every township. The land was sold by the state to private landowners. And at first, the landowners took ownership of the mineral rights in the sale. But by the 1950s, the state took ownership of 100% of the mineral rights from those 3.2 million acres, even after the land itself was sold. And according to Jody Smith with the Department of Trust Lands, the money the state makes off those mineral rights is important.
Over time, the state recognized that we would need that income and that resource in order to continue to sustain the budget for the state of North Dakota.
Well, all in all, the Department of Trust Lands collects about $1 billion every year by leasing the land to oil companies. $390 million goes towards K-12 education every 2 years. The remainder of that money goes into various state trusts. But back to that original question, who owns mineral rights underwater? That's been an ongoing debate since statehood. And it's especially important today because of the advent of hydraulic fracking. Energy companies can extract oil horizontally underground, making land under bodies of water much more valuable all of a sudden. And one thing that's clear, the state owns all of the land and mineral rights under the Missouri River that's within the boundaries of the ordinary high water mark. That's the section in purple. The high water mark is where the edge of the water meets land at high tide. Well, in the 1950s, the U.S. Army Corps of Engineers came in and created Lake Sakakawea. And at that time, the Wilkinson family sold its land here to the federal government, land which would be covered by water with that change. Now they're fighting the state for money they believe is rightfully theirs. I'm told by the family's lawyer, Josh Swanson, it's currently on appeal to the North Dakota Supreme Court. And the outcome of the Wilkinson's appeal will set a precedent for years to come.
There's no other state that's really going through this. So as we go through this and as these lawsuits go through court, we're essentially creating case law for the nation.
Nothing gives the state of North Dakota the right to claim ownership of these minerals.
Swanson says the Wilkinsons were able to lease their mineral rights to oil companies for 50 to 60 years after selling the surface rights in 1958.
The feds paid them for the surface. So you have hundreds of thousands of acres of some of the best farmland in North Dakota that would ultimately end up underneath Lake Sakakawea. When they did that, the private landowners, like my clients, reserved the mineral rights.
This brings us back to 2010, when oil companies discovered a way to get oil underwater, horizontal drilling. According to Swanson, it was right after this discovery that the state land board decided the underwater mineral rights now belong to them.
It just so happened one of my clients was on the state website, saw their acreage on there and said, this must be a mistake. They contacted the land board, who just brushed them off and said, we're going to claim it until a guy or a gal wearing a black robe, meaning a judge, tells us we can't do that. And to me, that's offensive, but it's what the state did.
Ever since the Wilkinsons made this discovery, they've been in legal battles with the state. They are currently on appeal to the Supreme Court in hopes of regaining their mineral rights. Swanson says the state taking his client's mineral rights is in violation of the Fifth Amendment of the U.S. Constitution. He says even though their land was sold and flooded, the Wilkinsons should still own the mineral rights up to where their property once met the Missouri River back in the 50s, or the original high water mark.
So the state is continuously working to try to identify where is that historic channel. And a couple of legislative sessions ago, they put through a bill called Senate Bill 2134, and that directed the Industrial Commission to conduct a study.
Commonly referred to as the Wink study, it redraws what the Army Corps originally laid out decades ago. Even so, Swanson pointed out the Wilkinsons' property right here at the bottom right-hand corner of the map. It's well above the newly determined high water mark that comes from the Wink study.
No matter how you slice this, there's no study, there's no declaration, there's no fiat that the state of North Dakota can claim that changes where the historical ordinary high water mark is. There's nowhere where they could draw them that would deprive the Wilkinsons of their mineral rights that have been with the family, and any other attempt to say so by the state or to gloss over it is nothing short of stealing.
So what you're saying is really there's no point in redrawing the line in the first place because the original line is all that matters.
Amen. That's exactly right. In a nutshell, that is exactly right.
Jody Smith couldn't comment on this specific case, but says the Wink line is now set in stone.
What we're trying to do is determine the acreage between the new line and the old line. So if we need to reimburse a private mineral owner for the royalties that we have inadvertently then received, we can do that.
To date, the Wilkinsons say the state is holding about $900,000 in royalties made off their 286 mineral acres since 2010. Smith says that money is currently frozen and it will be until the Supreme Court makes a decision. The case will be argued sometime late this spring.
Okay, and are the Wilkinsons the only family fighting the state this way?
Not by a long shot, Lauren. Swanson says 5 years ago he discovered that over $250 million was in dispute between landowners in the state. He estimates that number is much higher now. Smith says the state has about 500 leases along the river and knows there's a long road ahead full of legal battles that could affect the future of K-12 funding in North Dakota.
Renee, thank you very much. The Department of Trust Lands has more work to do. Senate Bill 2211, passed by state lawmakers in 2019, requires the department to take a closer look at all state-owned land along the Missouri, based on the new high watermark from the Wank study. Trust Lands recently contracted an engineering firm to do that. The firm's acreage adjustment should be completed in June. After it's done, there will be 2 years for landowners to contest the new line.
A woman wanted in connection to a